Further hearing in the appeal, Reyes against Malki and another.
Sir Daniel.
My Lord, my Lady, following on my 13 and a half minutes of fame last night, I'll pick up my submissions. There are two holdover points that I'd just like to address very briefly. The first one is the issue of assumed facts. And just to clarify, and there will be aspects of this that will be addressed by Mr. Swaroop more specifically
Yes.
in his submissions. We contest the jurisdiction of the Employment Tribunal to address claims of trafficking.
Yes.
And our case in doing so is that the trafficking allegation was deployed before the Employment Tribunal to defeat a claim of immunity, but that the indicators of trafficking were not pleaded in the Employment Tribunal claim form or in the statement of claim. I'll give you the references, but I don't propose to take you to the papers. They are MS 670 and MS 680. As a second point on assumed facts, we object to any finding that the appellant was trafficked by reference to the pleaded indicators of trafficking for the reasons that the reasonable grounds determination and the revised conclusive grounds determination were, as my Lord Wilson mentioned, were made without any process of inquiry involving the respondents or the Saudi embassy. We accept that there is evidence in the record that the policeman in question visited the premises, but that the subsequent inquiries were not undertaken to inform the reasonable grounds determination. And there is, given all this, a logical conundrum which has been recognized in some cases, and that is that on the appellant's pleaded case, a bare allegation of trafficking would require a diplomat to face a substantive trial, yet the diplomat is precluded from giving evidence. So that's the conundrum that we face. But having said all this...
Is precluded from giving evidence?
Is precluded.
Or can't be required to give evidence?
Well, can't be required, but the state can preclude him from giving evidence because...
The sending state.
The sending state can preclude him from giving evidence because the immunity is the immunity of the state, and the state can prohibit him from giving evidence. It is addressed in some of the commentaries that the
state can decline to waive a witness, a process of its objection to a process of compulsion. But there's nothing in the Vienna Convention which says that a diplomat who wishes to give evidence voluntarily can't do so.
Well, my Lord, there may be nothing explicit in the Vienna Convention that says that, but the diplomat would be in a rather invidious position if his immunity is owned by the state. The state precludes him from giving evidence. He then decides of his own accord that he would do so. He would no doubt be in breach of his own employment terms and conditions.
But that would apply if it was clearly a commercial case as well, wouldn't it?
It would.
So it's inherent in the system rather than inherent in the argument in this case.
Well, it is, my Lord, but it's one of the points that I'll come to, just a very brief point to make, that one has to interpret the treaty holistically, and it's got a number of moving parts, and I think that Mr. Otti has, for his own purposes, taken you only to the ones that suit him. But the issue of the preclusion from giving evidence is one that, if I can put it in these terms, infects the matter generally. Now, I appreciate...
turns. I mean, your argument basically turns on an aspect of the relationship between the diplomat and his employer.
Yes, indeed, and that he cannot be compelled by the risk.
Not in itself anything to do with immunity.
That's not to do with immunity, but the preclusion on the part of the receiving state from compelling him to give evidence in a trial is part of the convention.
But your main point is that if trafficking is to make all the difference here, it puts a premium on domestic servants alleging trafficking, and it may be difficult in one way or another, for diplomats to respond and rebut.
Yes, indeed, my lord, and I suppose there is the further point that Mr. Swarup will come to, and that is that in the case law on state immunity, including the jurisdictional immunities decision of the International Court of Justice, which Mr. Swarup will refer to, the International Court had precisely these kinds of concerns in mind when it said that immunity was a threshold issue and that it could not even be displaced by an allegation of a jus cogens breach. So no matter how serious the allegation of breach, one couldn't go through the immunity barrier. And in the jurisdictional immunities case, there was admitted unlawful activity by the German state, the Third Reich, in breaching the laws of war. And yet the International Court held that the character of those allegations was not material to the assessment of immunity. But as I say, Mr. Swarup will come to
state immunity.
That's state immunity.
Well, that's Jones and Saudi Arabia.
Yes, it is, and not to anticipate my friend's point, we've got the House of Lords in Jones and Saudi Arabia, we've got the ECHR, and we've got the International Court of Justice. But on the question of assumed facts, I was simply going to come to what I think is going to be the assistance to you, because I know my Lord Wilson was concerned about this. We accept that the only basis on which a claim, including a claim of immunity, can be heard is on the assumption of the facts pleaded in the statement of claim, because otherwise we could not get through to these proceedings. The second holdover point comes to the Article 39.2, the residual immunity point, and it's really just to expand on a brief point that I made yesterday. I indicated that A4 Law had applied for permission to intervene to make this point, and that we had objected and permission to intervene had been refused. I was reminded that the appellant had also objected to the A4 Law intervention. And then finally on this point, it's to confirm, my lords, my lady, what I said at the end of the day yesterday, and that is that if you do consider the residual immunity point to be material, we would like this court to deal with it and not to remit it back to the employment tribunal. And we considered that it would require a fully pleaded case and indeed a further hearing, because there isn't a pleaded case on this point in the appellant's written case, or indeed in its oral case. Now, with that, I will come to the respondent's case, and I hope that I will be able to assist you by really addressing Mr. Otti's oral arguments yesterday rather than his written case. His written case, we have...
Well, we have your respective written cases, and
yes, indeed.
Of course, will not treat you as having abandoned something merely because you don't deal with it in your oral argument.
Yes, indeed. I make the point preemptively because I'm mindful that my Lord Clark yesterday was very conscious of inquiring of Mr. Otti to identify where in his written case the issue was. But I'm going to be, if you like, disaggregating our written case and putting it back together.
Very helpful, thank you.
And I should say in opening that I'm grateful to my Lady Baroness Hale for correcting me in my moment of infelicity at the end of the day yesterday when I said that Mr. Otti's case was a case of ambiguity. I accept entirely that it's not. It's a case where he asserts a clear meaning and that the meaning is for him. And it's quite plain, and I'm sure will become plainer as the day goes on, that the appellant and the respondents come to this case from completely different angles. And we do so unabashedly. We are not going to try and meet Mr. Otti's 4 points and his detailed points of rebuttal seriatim, because we consider that he's simply addressing the Vienna Convention through the wrong prism, and we would like to correct that. So you have before you two competing interpretations of Article 31(1)(c), and the appellant's case that the provision is clear rests on three principal but rather broad contentions. The first one is the close relationship between diplomatic immunity and state immunity, and the commercial activity exception to state immunity. And he also relies on the state immunity cases interpreting the commercial activity exception. The second line of argument is the close relationship between diplomatic immunity and consular immunity, and he relies on consular immunity jurisprudence as well. And you'll recall the American case of Park against Shin,
Yes.
which he took you to, or rather he didn't take you to, but he referred to, if I recall correctly. And then the third line of jurisprudence that he relies upon is the case law interpreting and applying Article 39, subparagraph 2, the residual immunity case law. And that was Wakari against Kassem, and I think he took you to Mr. Justice Newey's decision, and that he also referred to Abu Sabib against Tadesi. So those are the three elements, broadly speaking, on which his case rests. And I'm constrained to say that the appellant's case is a case of reverse engineering, because it does not endeavour to construe Article 31(1)(c) by a reading of the text. It gets to the text, but only after it situates the text in a convenient location. And that convenient location is the same space as state immunity and diplomatic immunity. So in a sense, he's assuming what needs to be proven. And this is most evident when you look at the appellant's written case at paragraph 36 under the heading of ordinary meaning, and that's at MS 139. I don't propose to take you to it, but just to make the point and give you the reference, it's MS 139. Under the heading of ordinary meaning, the very first subheading is comparative case law on state and consular immunity. So before even looking at the text of the treaty, the appellant goes into the comparative case law on state and consular immunity. But our contention is that the appellant really needs to start with the text. And the allegation of trafficking and the allegation of the commercial nature of trafficking that is made really anticipates a review of the text rather than follows it. And if I may anticipate where I'm going to come to a little bit later in my submissions, I will, of course, get to the jurisprudence on immunity, but I'm going to propose to your lordships, your ladyship, that I will urge upon you to undertake what I've described here, at least for purposes of my submissions, a naked review of the treaty. Having a look at the treaty as it stands, without reference to the case law. None of the case law is binding upon you. You are free to write your judgment without regard to Tabian. So we're going to look at that in due course on the basis of a naked review.
Right.
I must also remark, because the appellant went to some length yesterday, as she needs to undermine the judgment of the Court of Appeal. But I must remark that the appellant's case has changed on appeal between the Court of Appeal proceedings and the House of Lords, and the Supreme Court proceedings. Although what is pleaded here was in broad measure pleaded below as well, the proceedings before the Court of Appeal also had another important element. And without sight of that element, it rather suggests that the Court of Appeal went off on a frolic of its own. And if you have a look at the Court of Appeal judgment, which is at MS 614,
Yep.
You will see that there is an identification of issues. And once again, I don't propose to take you to it, but simply to make the reference.
Yep.
And the interpretation case, as identified by the Master of the Rolls, was pleaded. But before the Court of Appeal, a breach case was also pleaded. That a finding of immunity would give rise to a breach of the ECHR and the Anti-Trafficking Convention. And it was in consequence of the appellant's breach case that, in fact, the judgment of the Court of Appeal went into some detail in cases such as Al-Adsani and Jones and so on. So, in defense of the Court of Appeal judgment, the case being presented here is a different one. And we contend that the Court of Appeal adopted the correct approach to first look into the issue of whether a contract of employment entered into by a serving diplomat with a domestic worker comes within the scope of Article 31(1)(c). Those are by way of introductory remarks. My submissions to come will be responsive to the appellant submissions under the following headings. I propose to start off with some baseline propositions, then to address one element of the factual background that we contend is material for your consideration.
Right.
Third, why analogies with state and consular immunities are inappropriate.
Yep.
Fourth, the correct approach to the interpretation of Article 31(1)(c). Fifth, the scheme of the Convention. And sixth, the interpretation of Article 31(1)(c). And I will attempt to address various issues that arose yesterday as I go.
Thank you. Thank you.
So, on the baseline propositions, the first proposition is that diplomatic immunity belongs to the state and not to the diplomat.
Yep.
And I suspect I don't need to address that in too much detail. Decision to waive is one for the state, not the diplomat.
This is common ground, yep.
Yes. Now, my Lord Sumption inquired yesterday whether a waiver showed the sovereign immunity nexus of diplomatic immunity. And it's helpful for me in response to that question put to Mr. Otti, just to say that our case is not that there is no link between state and diplomatic immunity. There patently is. There are common elements, but they have a different purpose and they have different rules. And the appellant has, therefore, rather deftly set up a straw man only in order to demolish him. And I will come to the state immunity, diplomatic immunity links and differences shortly. The waiver provisions of the Convention, we contend, support the respondent's case. And here I would like to take you to a document. The proposition is that a request that a sending state may waive immunity in the case of a domestic worker alleging abuse is an accepted mechanism under the Convention. And the document that I'd like to take you to is in the supplementary bundle. It's at tab 133 or page 76, if page 76 is an MS reference for a supplementary. Tab 183. So it's in that very slim additional bundle that you will provide.
Yes, I see. The last tab of the last bundle.
Yeah, yes, indeed.
Thank you.
Now, this is the Tier 2 and Tier 5 guidance for sponsors produced by the Home Office.
Yeah.
And I should note that the appellant came to the United Kingdom on a Tier 5 visa, and the reference of the Tier 5 visa certificate of sponsorship is at MS 143 to 144. But if I may take you to paragraph 4.21 on the document that I've just drawn to your attention.
Can you just remind me what the page reference was?
The supplement is page 76, and this
76.
paragraph is 79, on page 79.
Yep.
And
this is a fairly recent document.
it is, and I'll come on to that in just a moment. 421, an application for a sponsor license amounts to an acknowledgement that we, that is the Home Office, may seek from your head of mission or head of organization a limited waiver of inviolability and of immunity in order to enter your residence or premises to undertake compliance activity relating to your application of your sponsor license. So I'm addressing this simply in response to my Lord Sumption's point yesterday about waiver and why we say that it is for us, because there is an assumption that the diplomat will be covered by immunities when employing a private servant, a domestic worker. Now, my Lord Clark rightly identifies that this is 2017 guidance. Insofar as we have been able to establish, the issue was not addressed explicitly in the 2010 guidance, but the policy was identical. And to illuminate that for you, if I may take you to two government statements made in the House of Lords, which are at Authorities 13, tab 157, and the MS reference is MS 5049. what we have in this extract is two different statements on two different days. The first by Foreign Office Minister Lord Howe, and the second by Home Office Minister Baroness Browning. And if I can take you to 5049,
Yeah.
you'll see that this is in response to a question asked by Baroness Cox to ask Her Majesty's Government what measures have been taken to protect the human rights of migrant domestic workers brought to the UK by foreign diplomats. And Lord Howe for the Foreign Office says, in accordance with the convention, the Vienna Convention, foreign diplomats accredited to the UK are entitled to employ domestic workers, foreign or British. Under Article 41.1, the Vienna Convention, of the Vienna Convention, it is the duty of all diplomats to respect the laws and regulations of the receiving state. This applies to the terms and conditions of employment for all domestic staff. The Foreign Office remind all foreign missions based in the UK of their obligations. Then he goes on to say, the police investigate any allegation that the law has been broken by persons entitled to immunity and report the results to the FCO. Given the number of people entitled to immunity in the UK, around 25,000, the number of serious offences allegedly committed by diplomats has remained proportionately low in recent years. Just 2 cases involving a domestic worker in 2010. The FCO, and this is the relevant part, the FCO treats any allegation of mistreatment of domestic workers in diplomatic households very seriously. When an allegation is brought to our attention by the police, we liaise as necessary with a relevant diplomatic mission and the UK Border Agency to work for an appropriate response. If an allegation of mistreatment requires further investigation by the police, the FCO will request from the diplomatic mission concerned on behalf of the police a waiver of the diplomat's immunity. I interpolate, there is an assumption that immunity applies. Failure to provide a waiver may result in a request to the mission for withdrawal of the diplomat. And then...
I see why that this could be said to help you. On the other hand, it's simply saying what the government's understanding of the law is, and in the end, it's we who decide what the law is, not the government.
My Lord, I entirely accept that it's you, the Supreme Court, who decide what the law is, not the government. But there is a larger issue here, and that is we are concerned with the interpretation and application of a treaty to which there are 191 parties. Yes. And the Supreme Courts of a number of jurisdictions may and do have sight of these matters. When it comes to the interpretation of the treaty, while the views of the government will not be controlling, they, I would submit, will certainly be important. They won't be dispositive, but they will be important.
But this is a very interesting answer that you've drawn our attention to. On the one hand, it appears to accept or suggest that there isn't an immunity in respect of employment of domestic workers, but secondly, that there is an immunity in respect of police inquiries with a view to prosecution, for which clearly a waiver would be required, because diplomatic immunity covers the whole of the criminal law.
My lady, I'm not sure that I'm with you on the first point, because I don't see this as accepting that there is...
Well, it could be read in such a way, undoubtedly. The point I'm getting at is that the point that you're relying on could simply be relating to police inquiries with a view to criminal proceedings. Well, we are not involved in that. This is not our business.
That I accept entirely. That this is focused on the police investigation. I don't think, with respect, that I'm there on the question of whether this assumes that there is no immunity.
No, I understand that. It can be read in either way.
And may I, just for completeness, also draw to your attention what Baroness Browning had to say, and that's on MS 5057. I won't read it out. It's slightly more elaborate, but it follows the same detail of Lord Howe. The points I suppose that I was going to go on to make was that the proposition as regarding waiver being for us goes also to the appellant's case about declaring a diplomat to be persona non grata under Article 9 of the VCDR. I'll take you to that later when we look at the convention in more detail, rather than now. But you will well appreciate that declaring a diplomatic agent to be persona non grata, or PNGing them, as it's colloquially known, is a mechanism that is available to a state in case of alleged abuse of diplomatic workers. But our contention is that that remedy implies immunity for the alleged conduct, and I suppose to address Baroness Hale's, my lady's observation,
Neutral, I think, on the
that covers all immunities, whether it's civil or criminal. And there is nothing in the process of declaring a diplomatic agent to be persona non grata that comes to an appreciation of whether a matter is within their, quote, official functions or not. Indeed, PNGing is something that a state can use for purposes of following an appreciation of a criminal breach, of a civil breach, of spying, or simply to send a message. But the fact of PNGing is, we say, an affirmation of immunity. The second proposition is that the case concerns, I hope it's straightforward, but I will try and use it to make some wider points in response to the submissions yesterday. It is that the case concerned treaty commitments that apply between the United Kingdom and Saudi Arabia, on which the appellant founds her rights. This is not simply a case which involves, if you like, the United Kingdom looking inward at itself alone, and it's not a case involving the United Kingdom and the conduct of some other Council of Europe state, where it might be said that the ATC can be relied upon because they are, so to speak, parties in common. Now, Mr. Otti yesterday handed up a table of Saudi and UK treaties. The only treaties on that table, post-dating the Vienna Convention on Diplomatic Relations, that are in common between the two states, are the Vienna Convention on Consular Relations and the Palermo Protocol. Now, I say for completeness, I imagine I don't need to say so, but Saudi Arabia is not a party to the European Convention on Human Rights. It's not a party to the Anti-Trafficking Convention, and it's not a party to the Treaty on European Union. And I will show, I hope in my submissions later this morning, that the Vienna Convention on Consular Relations is a very flawed analogue indeed, and we would say is not relevant. And my friend Mr. Swaroop will address the Palermo Protocol. So that leaves the appellant's prior treaties on Mr. Otti's list. And they include the Slavery Convention of 1926, the Forced Labour Convention of 1930, the Supplementary Convention to the Abolition of Slavery in 1956. But the issue of prior treaties raises a number of rather difficult questions we would submit for the appellant. First of all, it raises the question as to why an express exception to immunity was not laid down in the VCDR itself. If, as Mr. Otti suggests, there was this groundswell, this momentum behind a restrictive immunity approach for diplomats when it came to 1961 in the light of these prior treaties that he puts before you, why was this not addressed in the Vienna Convention? I will come back to the travaux préparatoires because I appreciate that there was some caution in the exchanges yesterday about reference to the travaux préparatoires, but a review of the travaux préparatoires show one reference to this and not in the context of the provision that we are concerned with. So that's the first difficulty with prior treaties. The second difficulty with prior treaties is that prior treaties, particularly of this nature, immediately raise the question of later in time and specialist treaties, which one prevails. And the appellant has to meet the case that the VCDR, which is both a later in time treaty and a specialist treaty on immunity, does not establish immunity for such conduct, and we contend that he can't do so. The third, and we would say perhaps the most important of the concerns about prior treaties, and if I may take you to the Vienna Convention on the Law of Treaties here, which is at Authorities 553 at MS 2317.
Thank you. Yes.
2317 is what Mr. Arty talked to yesterday, which is the...
Yes, we looked at Article 31.
Yes. Now,
by coincidence, yeah.
if you have a look at Article 31, subparagraph 3, there are 3 subparagraphs, but you'll see that that 31, 3A and B,
Yep.
both concern subsequent agreements and subsequent practice, or each concern, one concerns subsequent agreement, the second concerns subsequent practice. And they provide that a subsequent agreement between the parties regarding the interpretation of the treaty or the application of its provisions may be taken into account, or subsequent practice in the application of the treaty, which establishes the agreement of the parties regarding its interpretation, may be taken into account. There is no suggestion here at all that prior treaties are going to be relevant. Now, the appellant tries to shoehorn this into other relevant rules of international law, which I'll come on to shortly. But the prior agreements going back to 1926 don't assist the appellant. And the last reason why they don't assist the appellant is that the appellant is not founding any substantive rights on these treaties. The appellant is putting these treaties before the court as atmosphere or as momentum, but they are not saying that there is an allegation of the breach of a particular convention in issue in this case. Now, the appellant then goes on, no doubt mindful of these concerns about prior treaties, to refer to Article 31(3)(c), which is the language of any relevant rules of international law applicable in the relations between the parties, and urges upon you to take that into account. And with enormous respect to my friend Mr. Otti, he suggests that this provision amounts to a principle of harmonious interpretation, and that is plainly not the case. And there are 3 points that I'd like to make by reference to this provision, and I would like to take you to the language of it, and if I may use that as a brief, an opportunity for a brief aside. I mean, the appellant's case, it's always a great pleasure to listen to Mr. Otti. He was very fluent and almost compelling, but it was at a level of generality. He did not take you to the detail of many of these provisions. I would like to focus on the detail because our case rests in the detail. And subparagraph C says, any relevant rules of international law applicable in the relations between the parties. The interpretation exercise is not an exercise of taking a carefully negotiated treaty with 191 state parties and treating it as an empty vessel into which you can pour the rest of international law at your whim. And the reference to applicable in the relations between the parties, we say, is a reference to what is applicable between the United Kingdom and Saudi Arabia. And that does not include the ATC, that does not include the ECHR, that does not include the Treaty on European Union, and indeed, if it was relevant, it does not include the Arab Charter on Human Rights. And that's our principal contention. We have a subsidiary contention as well, just to complicate matters, and that is that this is a treaty of 191 state parties. If you were, for any reason, against us on the interpretation of the words in relations between the parties and suggesting that that should not be so narrowly focused as just on the relations between Saudi Arabia and the United Kingdom, the only alternative is the relations between the parties to the treaty as a whole. And the contention then would have to be, on the appellant's part, that to come within the scope of subparagraph 3C, the other relevant rules provision, Mr. Otti would have to show the practice of 191 other states, or 189 other states in his favour. Now, this is not to say, lest you may be thinking that this is a very heavy hammer indeed to the crystallization of old treaties. It's not to make that point, because states can agree separately, small communities of states. I think my Lord Sumption raised the question yesterday about regional treaties versus multilateral treaties, and I'll come back to that in just a moment. But it is open to regional states or groupings of states to reach agreements on the content of the law in the VCDR, and to say that as between themselves, they will apply different rules. And indeed, the Council of Europe had an opportunity in the Anti-Trafficking Convention, in the ATC, to do just that. It would have been very simple and straightforward had there been agreement of the Council of Europe states to have a short provision which says something to the effect of claims of state immunity, claims of diplomatic immunity shall not arise in respect of allegations of trafficking. They didn't do so.
Well, that wouldn't have been relevant as against a non-member of the Council of Europe.
That's exactly my point, my Lord. It wouldn't have been. But it's simply to say that the point that I'm making to you is not to say that this is a sledgehammer which precludes all, if you like, progressive development. I think my Lord Wilson yesterday suggested that it would be sort of remarkable if a treaty could be read down by the unwillingness of states to sign up to progressive rules. Where there are states that would like to sign up to progressive rules, they can do so. That, for purposes of the Vienna Convention, may be relevant as a subsequent agreement, or it would simply apply as a lex posterior, if you like. But I agree, my Lord Sumption, with your observation entirely, that this would not assist in the present case, and that's precisely our point. The appellant is attempting to use Article 31.3c of the Vienna Convention on the Law of Treaties to get around the limitations that are evident in Article 31.3a and b of the Vienna Convention on the Law of Treaties, which require subsequent agreements and subsequent practice to go to the agreement of the parties relating to interpretation. Now, there were the two questions put to Mr. Otter yesterday. My Lord Wilson, the question that I've just referred to, that it would be odd if the Vienna Convention was to be read down by states failing to sign up to a slavery exception. And my Lord Sumption, the question about is there a point to be taken about the Convention on Human Rights being a regional convention and the VCDR being a global convention. This comes also to the point, my Lord Neuberger, that you put to me a moment ago, that it's this court that will decide the law. Well, the global character of the Vienna Convention on Diplomatic Relations is hugely important, of absolutely cardinal importance. And you see this in the submissions of the Secretary of State in these proceedings. And the universality of the convention would be very significantly, if not fatally undermined, we say, if it was given different meanings in different parts of the world by reference to regional instruments. Now, I accept entirely that an express agreement of the Latin American states or the Council of Europe, which dealt with immunity between them, would not fall foul of this. But the incremental evolutive agreement by courts in different jurisdictions would raise immense problems. You would have the Foreign Office or the State Department or the Saudi Ministry of Foreign Affairs having to keep tables about sort of ratifications and what various courts were saying about the provision. So the VCDR is, in our view, a baseline. It can be revised. There can be subsequent agreements or practice regarding interpretation. But the meaning of the Vienna Convention on Diplomatic Relations does not wax and wane with changing sensibilities, absent the agreement of the treaty parties. And this is not to diminish for one moment the proper concern about anti-trafficking, about trafficking, just like it's not to diminish claims of grave breaches of the Geneva Conventions or of torture. But the interpretation of a multilateral treaty in these circumstances does not change with changing sensibilities unless the parties, as it were, seek to revise it through subsequent agreements, subsequent practice, protocols, and so on. And my Lord Neuberger, going to your point, just to repeat what I said, this is why the views of the executive we would submit that are responsible for negotiating treaties and for the conduct pursuant to treaties warrants some deference. Now, we are
the danger is that it's looking at one country, one executive of one out of 191.
Yes, I appreciate that.
It's back to the problem you've identified.
Yes, I appreciate that entirely, and it's one of the reasons why I'm saying candidly that it's not controlling, it's not dispositive, but it's certainly material. Insofar as we are able to and put before you the views of states, the other view of a state that is significant in this respect is the State Department, and I'll take you to the views of the United States.
But don't let's forget, you're urging upon us, reasonably enough, the views of the Foreign Office.
Yes.
Now, the Home Office has very strong views about modern trafficking.
Yes, indeed.
Very well.
I don't dispute that for a moment. The Home Office and the Foreign Office, HMG, in its corporate persona, could, no doubt in a number of ways, develop that agenda further. They may say that, in fact, they are addressing the matter as best they can within the scheme of diplomatic immunity. My Lord Wilson, I really want to be sure that the court is not mistaking anything that we say on this side of the room for a lack of regard for the seriousness of trafficking. That's not our case. Our case is
Your point is that everyone feels very strongly about torture as well.
Yes.
That didn't stop the House of Lords in Jones and Saudi Arabia from saying that state immunity prevented that particular claim being pursued. The same point, isn't it?
It is the same point, and in the jurisdictional immunities case, Germany and Italy before the ICJ, there was an admitted breach of war crimes.
Yeah.
But I mean, I don't see how it arises anyway on the way that Mr. Otti puts his case. He was very careful to say that he was not relying on a competing international rule of law of higher order, which was essentially the jurisdictional immunities issue. He is relying on the construction of an express exception.
Yeah.
So on that footing, you know, whatever moral revulsion one might have against trafficking is not in point. What is in point, primarily, is whether the recipient of trafficked employees is engaging, by virtue of the financial implications of that, in a commercial activity.
My Lord, I accept that, and I agree with that characterization of the appellant's case. But to coin a phrase, location, location, location. I mean, Mr. Otti is locating his case in the space of sovereign immunity, of state immunity and consular immunity, and we just think that he's wrong to do so. I think that this is a trick of light. I mean, I say that obviously with the greatest respect to my friend Mr. Otti. There is a further point that I'd like to pick up on the appellant's submissions yesterday, and that is that he referenced two cases: the Tehran hostages case that ranged from 1979 to 1981 before the International Court of Justice, which arose out of the seizure of the American diplomats and consular staff in Tehran, and the Kubrigad case, which is at tab A11 Authorities 11, 125 at MS 4626. And I would like to take you to this because it's a case that illustrates a number of points. And it was a case that was before the Court of Appeal.
Which flag is this?
Sorry, it's tab 125, Authorities A11, MS 4626.
Thank you. Yep.
You will see at the back of this case, but that's not going to be the principal document to take you to. You will see from MS 4640 and following a number of contemporaneous press reports about this case. You may well remember this case because it was very much in the media just about the time or just before we had the Court of Appeal hearing. This is a case that concerned Mrs. Kubrigad, a citizen of India, who was, as is evident from the discussion or the background at 4626, was a consular officer in the United States from October 2012 to January 2014, a position that cloaked her with consular immunities under the VCCR. She contended that she additionally obtained diplomatic immunity in 2013 by virtue of her appointment as a special advisor to the United Nations. Now, the allegation against Mrs. Kubrigada was that she was engaged in visa fraud by the employment and then the subsequent abuse of a domestic worker in her consular status. Now, there are a number of points that I'd like to make by reference to this case, and I'll come back to it also later in my submissions. The first one simply by reference to the press articles, and I won't read out the detail, but you will see that the press articles identify that the case led to the recall of an ambassador. It led to the what was perceived to be a tit-for-tat detention of a US off-duty policeman in India, and it soured relations. And the Secretary of State in this case has very properly and explicitly voiced concern in language I would submit of necessary caution in a public hearing, but quite clear, identifying the kinds of concerns that arose in the Kubrigada case.
But this is reciprocity and so on.
Precisely, it's reciprocity, and it's the vulnerability of British diplomats in circumstances in which there are cascading effects and unintended consequences flowing from an interpretation which is perceived to go outside of the four corners of the convention.
I mean, I see the concern about diplomats being subject to, in some jurisdictions, to trumped-up allegations. But that issue is present whatever the answer to these questions, because it's not an unqualified immunity, at least in relation to civil matters. So if you're going to have diplomats in a state where people are liable to trump up charges, it's easy enough to trump up something that is outside the immunity as expressed.
My Lord, you anticipate a point that I will come on to, if I may, a little bit later on, when I deal with the interpretation of official functions, because I think that is precisely one of the concerns, and it's one of the reasons why official functions cannot be addressed by reference to the sliding scale of Mr. Justice Langstaff in Abu Sabib, because in effect what a sliding scale would do is would simply submit every allegation that came within the per se, if you like, the apparent corners of an exception to an evidential determination, which would raise enormous difficulties. But the Kubrigada case also illustrates three other points which I'd like to make very briefly. First of all, it turns on absolutely fundamentally the difference between the VCCR and the VCDR. One of the reasons why, as emerges from the judgment, why Ms. Kubrigada subsequently became a special advisor to the United Nations was precisely because it gave her greater immunities than she had under the VCCR. And it goes to the inaptness of the analogy of the appellants in relying on VCCR immunities to read into the VCDR. The second point that I'd like to draw to while I'm with this case, although I'm taking it a little bit out of sequence, is I'd like to invite you to turn to page 4633 in that judgment. And you'll see at the bottom of page 4633 that the US government argues that the indictment against Mrs. Kubry-Gardner should not be dismissed because she did not have diplomatic immunity at the time of her arrest and has no immunity at the present time she had left the country. In support of the US government's position, the government submitted a declaration from Stephen Kerr, an attorney advisor in the Office of the Legal Advisor of the United States Department of State. So here we have the United States government stepping into court through the State Department, giving a view on whether immunity applies. And the court rather deftly, in the next paragraph goes on, even assuming Kerr's conclusions to be correct, which rather implies that they're not, the case must be dismissed based on Kubry-Gardner's conceded immunity on January the 9th, 2014. And we say in response to Mr. Otti's attempt to undermine the whole swathe of US jurisprudence by reference to what he describes as the doctrine of deference, that deference needs to be understood for what it is. And while I'm here, my lords, my lady, there's one additional case that we've handed up.
Yes.
Which is one of the Supreme Court judgments that deals with the doctrine of deference. It's the case of Colivrat against Oregon. I really don't need to take you to the detail of the case, other than to identify that what was in issue was an 1881 treaty between the United States and Serbia. And if I may, I'd like to invite you to go to page 5 of that judgment, and to paragraph 4. And you will see there that the Supreme Court said, while courts interpret treaties for themselves, my Lord Neuberger, exactly as you put to me, while courts interpret treaties for themselves, the meaning given them by the departments of government, particularly charged with their negotiation and enforcement, is given great weight. And the point that I would make here is that we are not disputing the doctrine of deference. Mr. Otti has put it on the table. We accept that it's there. We are just clarifying what it means. And by reference to the Kubry-Gardner decision, it's quite clear that the US courts will exercise the same kind of scrutiny and indeed caustic scrutiny over submissions of the State Department as the Supreme Court.
That was the case where it was a bilateral treaty, and
Yes.
the documents relied on were documents to which the two parties to the treaty were party.
Yes, indeed.
Not where one of 191 states said what they thought, or may have said what they thought.
Yes, indeed. My Lord, I accept that entirely, and that the practice of one state, when it's a treaty of 191, becomes rather more complicated to assess.
It seems undeniable that the influence of the State Department in decisions of the US courts on US foreign relations, this is not only a concept which is completely alien to our Constitution, but that influence is in practice very strong. The adoption of the qualified basis for state immunity, the revisions in the 1960s of the previous rules in the United States about foreign act of state. These are examples of cases where the law has been radically changed by judges at the invitation of the State Department. This is not something that would happen here in that way.
My Lord, I'm not sure that I'm qualified to answer whether that happens here in this way or not. Certainly it feels as if
Unless, of course, it corresponds to a general state practice, but that's not the basis on which the US State Department intervenes in cases.
I think one point to note about that is that there may be an appearance of a heavier influence because as a matter of sometimes law and as a matter of practice, there is an obligation on the government to make its views known, where it's not always the case that the government will make their views known.
Well, it arises from the constitutional assignment of exclusive responsibility for the United States foreign relations to the executive, which is a great deal more absolute than it would be here.
And, my Lord, I accept that entirely. I mean, my observation goes to the appellant's invitation to you to sweep away the whole swathe of US jurisprudence without even examining its details simply because of the doctrine of deference, and we just don't think that that's warranted. There is also a point that arises under the Kubicadi decision, and that is that loss of immunity on departure does not cure a lack of jurisdiction when proceedings were commenced, and that's at MS 4634.
The relevant date was the date when the indictment.
Yes, and my lady, to be fair, I think that there is in the limited case law of which I'm aware, there is some debate about whether the relevant date ought to be the date of the indictment or the date of the first decision. There are cases which Mr. Otti will draw to your attention, no doubt, in which it was the date beyond the date of indictment. The third proposition is that diplomatic immunity is reciprocal in nature, even if it's governed by a multilateral treaty, both in legal terms and in the practical reality of the application. And in the interest of time, I would simply like to refer you to, but not to take you to, two provisions. The first one is Article 47(2)A of the VCDR, which is at MS 1001, Article 47(2)A, and then also to Section 3 of the Diplomatic Privileges Act, which is at MS 969. And both of those address the ability of a state to act restrictively in response to a restriction of the immunity of counterpart of another state. So it would not, for example, be a breach of the VCDR if United Kingdom law were to take a turn in a particular direction and a foreign state were to take issue with that and seek to impose similar limitations. And the Secretary of State's very real concern here is expressed in the submission in his name, which is at Core Volume 1, MS 581. It's MS 581 at paragraph 11. I don't propose to take you to it, but it's a very clearly set out concern. I'd like to move on from there to one element of factual background, which I will go through very quickly, but which we say has a bearing on your decision. It's not disputed that Mr. al-Malki was accredited as a diplomat at the Saudi mission in London from 22nd of July 2010. There is a Foreign Office certificate in the papers, which is at MS 773 and 4. MS 773 and 4. It's a Foreign Office certificate. On the basis of our acceptance of assumption, the appellant was employed by the respondents from mid-January 2011 until the household on the 14th of March. It is part of the appellant's evidence that on that date, on the 14th of March, and then again subsequently in April, a month or so later, the Foreign Office was informed by the police of these developments, and you will see this at MS 759. MS 759. Now, as I've already addressed by taking you to Lord Howell's and Baroness Browning's statements in the House of Lords, HMG policy concerning claims of abuse of diplomatic workers is to facilitate their investigation where it appears that further investigation is warranted, and indeed to request a waiver of immunity if that is warranted. Now, no attempt was made to contact the embassy by the Home Office or the UKBA as part of their reasonable grounds determination or subsequently. No waiver of immunity was sought. Mr. Malki was not declared persona non grata, and he remained an accredited diplomat at the embassy until the end of his posting on the 29th of August 2014. Now, the point of relevance here, and again, in the interest of time, I won't take you to this, but simply refer to it. If you have a look at the Tehran hostages decision of the International Court of Justice, which is at MS 1335, it's A2 tab 10, MS 1335, and at paragraphs 86 and also paragraph 83 preceding that, you will see that the International Court of Justice talks about diplomatic privileges, or the convention being a self-contained regime. And I see, as it's being looked up, perhaps I will take you to it. Perhaps I could start on paragraph 83, which is at MS 1333. And just the last sentence, it's elaborated over the page, but diplomatic law itself provides the necessary means of defense against and sanction for illicit activities by members of diplomatic or consular missions. And then paragraph 86, in more detail, the rules of diplomatic law constitute a self-contained regime which on the one hand lays down the receiving state's obligations regarding facilities, etc., and on the other foresees their possible abuse by members of the mission. These means are by their nature entirely efficacious, for unless the sending state recalls the member of the mission objected to forthwith, the prospect of the almost immediate loss of privileges and immunities because of the withdrawal of the receiving state of his recognition will in practice compel the person in his own interest to depart. And it goes on to say, the principle of inviolability of persons and agents on the premises of the mission are one of the very foundations of this long-established regime. And the small, but I hope important point that I'd like to make by reference to this is that, and again, it comes to the point raised by my Lord Wilson, that the United Kingdom, through the Home Office, through the UK Border Agency, through the Foreign Office, works within the self-contained regime of the law. And the Home Office policy guidance that we have given to you at MS 4972, and the guidance to sponsors that I took you to earlier, which is at supplementary 3, tab 183 at page 76, both work within the framework of the VCDR. And the 3 points that I would like briefly to make from this is that, first of all, the employment of private servants in diplomatic households is explicitly envisaged in the VCDR, and I'll come back to that in more detail. Second, it is explicitly addressed in the Home Office and UKBA guidance, the employment of private servants. This guidance proceeds on the clear understanding that such matters are framed by the VCDR. And indeed, I'll come back to this, there is a formal requirement in this country for purposes of an application for a sponsorship license for a tier 5 visa for a domestic work in a diplomatic household, the sponsor must be a diplomatic agent and the head of the mission must provide support. So this visa that Ms. Reyes came to the United Kingdom on could only have been sought by a diplomat with the support of the head of mission. Now, I will have points to make about official functions, but you can see where this is going. This is not an employment that could have happened by by anyone other than someone who is entitled to diplomatic immunities and privileges. It is a prerequisite for such a certificate of sponsorship that there are privileges and immunities attaching to the diplomat. And the third point is that concerns about abuse are addressed through VCDR-consistent mechanisms. There may be arguments that they are inadequate, and no doubt it's not beyond the wit of policymakers and lawyers to develop them further. But concerns of abuse are being addressed by a formality of a sponsorship mechanism, by a latitude to refuse an application for a visa, by HMG's stated policy of diplomatic level engagement, by a clear affirmation that a waiver of inviolability and immunity may be sought, and ultimately by the long stop of being able to declare a diplomat persona non grata. Now, I accept again, as I've done throughout, that the United Kingdom practice is not dispositive, but it's clearly material. Let me turn now, if I may. I realize I'm going rather more slowly than I should be. So my apologies if I skip over some elements, but to turn to the issue of why analogies with state and consular immunities are inappropriate, which is at the very heart of the appellant's case. And in our contention, we believe that this is simply not a sustainable proposition. Now, Mr. Otti, very deftly by reference to Trentex Trading Corporation, put it before the court that at the time that the Vienna Convention on diplomatic relations was being negotiated, that the developments were underway in favor of the restrictive approach of state immunity that Lord Denning and others in Trentex subsequently referred to. And he also quite properly pointed to the fact that the Vienna Convention on Consular Relations was being drafted and negotiated at the same time. He said it follows from this that the drafters and signatories of the Vienna Convention on Diplomatic Relations would have been aware of these developments and intended to reflect them in the VCDR. Now, we agree that a restrictive approach to state immunity was beginning to emerge in the late 1950s and early 1960s. I mean, in the United Kingdom, it took 2 decades to legislate on that, but we agree that that restrictive approach was beginning to emerge. We agree that the Vienna Convention on Consular Relations was beginning to be negotiated at that time. And we absolutely agree that the International Law Commission members and governments would have been very well aware of these parallel developments. I take a point now which will be taken against me later on, but the member of the International Law Commission of the United Kingdom at the time of the negotiation of the VCDR was Sir Gerald Fitzmaurice, who was the legal advisor of the Foreign Office at the time that he was sitting on the ILC. So there is no doubt at all that there was joined up appreciation of all of these developments. But in our submission, what this shows is that the absence of a clearly stated exception, restrictions and limitations in the VCDR, was very clearly a policy choice. Everything else was happening in tandem. Why was an exception with the clarity that Mr. Otti seeks to contend for not explicitly written into the VCDR? And in our contention, that it was a policy choice. And the question is, why was a different approach taken? And if I may say with respect, sitting on the other side of the room yesterday, there seemed to be a worrying inclination developing towards an agreement that it was counterintuitive for a state not to be immune, but for a diplomat to be immune for a parallel contract of employment. And I think my Lord Sumption gave the example of a waiter. Why should a state not be immune, but the diplomat immune? And Mr. Otti, I think, put it in terms of an unprincipled divergence of approach. But with respect, there is a very, very plain and self-evident reason for the difference in approach. Diplomats are corporeal beings who are physically vulnerable. States are incorporeal and can look after themselves. And this has always been the concern, which is why the language in the recital of the convention is focused on the functions of of diplomats. If diplomats were not given these protections, they would not be sent into difficult places and difficult circumstances. So it's the corporeal character of diplomats which we contend is at the heart of the difference. And again, if I may, draw your attention to the Secretary of State's expressed concern at paragraph 11 of their intervention, which is at MS 581.
Yes.
So the question then arises, and no doubt would otherwise be put to me by Mr. Otti, well, what about the Vienna Convention on Consular Relations? Why did that take a different approach? And there are three reasons. First of all, it's a different regime with explicitly different language, and you can't, as a first proposition, read across from the VCCR into the VCDR. Because
That's basically saying it takes a different line.
Yes.
It's not an answer.
Well, my lord, it takes a different line. I mean, Mr. Otti was attempting to suggest that in fact the two should be read together and that the VCDR should be interpreted by reference to the VCCR, and he drew Park and Chin to your attention. Yes. What I'm saying is that there is a policy choice, but in response to the question, well, what about the corporeal vulnerability? Article 3, paragraph 2 of the VCDR, which I don't need to take you to, but it's at MS 990, Article 3.2.
3.2.
3, paragraph 2.
Thank you.
Provides that nothing in the present convention, the Convention on Diplomatic Relations, shall be construed as preventing the performance of consular functions by a diplomatic mission. And what is evident that certainly in many circumstances that diplomats perform consular functions precisely to give them the immunities of the diplomat. Now, Mr. Otti did not take you to the VCCR. I will do so in just a moment, but what I would like to do very rapidly is to make some points about state immunity and between state immunity and diplomatic immunity. And as I mentioned in opening, it is not our case that these are different bodies of law that just pass in the line. There are lots of similarities and overlaps. They both derive from international law, both immunities from jurisdiction, both municipal law as a constraint on the exercise of territorial jurisdiction by the executive courts, but they both ultimately serve the interests of the state. And it is no part of my case to joust metaphorically with Mr. Justice Laws in prop end about whether he got the nuance of that right or wrong. But there are material differences between them, and let me analytically just try and identify a number. First of all, there is a different legal rationale. The one is sovereign equality, the other is functional necessity. Mr. Otti took you to the Aldona S case, which is at authorities 174, which is in and also in the supplementary bundle, third supplementary bundle.
So what did you say was the basis of diplomatic immunity as opposed to sovereign equality?
Well, my lord,
functional necessity.
Functional necessity, and the way it was described in the Aldona S case, with apologies for my Latin, is ne impediata legato. The legation may not be impeded, as opposed to par in parem non habet judicium, equals shall have no jurisdiction over one another. And that's Aldona S. So the legal rationale of the two is different. The sources of law of the two are different, and this is rather critical, because at least today, noting that the UN Convention on Jurisdictional Immunities of States is not yet in force, and the United Kingdom has not ratified. As a matter of global law, state immunity is found in customary international law, whereas diplomatic immunity is found in a multilateral treaty. And that is...
Diplomatic immunity, long before the treaty,
yes,
was a matter of customary international law.
My lord, I accept that, but with respect, that's not material to the point that I'm making. The point that I'm making is that state immunity in customary international law evolves through the practice of states. Diplomatic immunity, crystallized in the Vienna Convention on Diplomatic Relations, has to evolve through treaty mechanisms. Third difference is that state immunity deals with incorporeal subjects, whereas diplomatic immunity deals with corporeal corporeal subjects. And then the fourth point, which is the most telling, is that there are different substantive rules. And even if the language may be similar, such as the man or woman on the Clapham omnibus may say, well, immunity is immunity, and what's the difference? One's got to look at the detail. And just to illustrate, inviolability is not found in state immunity. State immunity does not contain rules on immunity from criminal jurisdiction. There is a different approach, we would contend, state immunity, an approach which is avowedly a restrictive immunity approach, whereas diplomatic immunity, we would contend, is extensive, almost absolute immunities, but for very, very tightly constrained exceptions. And indeed, it is perfectly possible it would have been perfectly possible for legal draftsmen to have crafted diplomatic immunity exceptions to mirror state immunity exceptions, had that been the intent. That wasn't the intent.
Would it have been difficult to do so in relation to family members, part of the household?
My lord, I don't know necessarily why it would be so difficult to do so.
If one is looking simply at whether the relevant act is an act of sovereign authority, that can be related to the performance by a diplomat of his own functions, but is on the face of it irrelevant to a family member who doesn't have.
My lord, with respect, I think that there would be multiple ways in which that could be addressed. Simply, for example, by saying that the family member is recovered by the immunity of the diplomat, sort of irrespective, and then have savings clauses if this was necessary. The concern being that family members may be vulnerable, even if diplomats may not be. So I don't think that it would be beyond the wit of draftsmen and women to come up with clauses, had that been the intent. Now, appreciating that she's sitting behind in the court, I'm going to spare the blushes of Dr. Webb and not read out the detail of Fox and Webb, but there are elements of it in the bundle which address precisely this issue of the difference between state immunity and diplomatic immunity, and we would commend them to the court. And this
Here's
is
the references.
Yes. So it's Authorities Bundle 3, tab 32, and it's MS 1825. And the extracts are at MS 1832 to 1845. It's a section which is devoted particularly to this subject.
Yes, I remember. Thank you.
And the point I would make here is that the fact that these related bodies of law were developing in parallel indicates that a legislative choice was made not to adopt a restrictive immunity approach in the VCDR. The appellant suggests that the commercial activity exception in Article 31(1)(c) is clearly a mirror of the commercial activity exception in state immunity. And our contention is that there is no support for this whatever in the ILC records, in the records of the Vienna Conference, in academic commentaries or elsewhere. And again, with the warmest of respect for my friend opposite, this is a litigation lawyer's construct. It's not only his, it happens also in the United States and elsewhere, but this is a litigation lawyer's construct. It's got no bearing at all with the realities of the Vienna Convention. So in our view, state immunity jurisprudence and the commercial transaction exception does not translate into diplomatic law. And I'm going to take a leaf out of Mr. Otti's book, and I'm going to sweep away a whole raft of his jurisprudence, if I may. Re-Canada Labour Code does not assist as a state immunity case. El Haddad against the United Arab Emirates does not assist as a state immunity case. And a diplomatic immunity case, Single against Babisale, which he drew to your attention yesterday,
Yes.
we believe doesn't exist either, because frankly, it simply drew on state immunity analogies, which it should not have done. So we think that all of that case law is not apposite. I would like now, if I may, to turn to consular immunity, because there may be a more superficial sort of appreciation, if I can put it in those terms, that consuls and diplomats are entitled to the same immunity. The Vienna Convention on Consular Relations is at A4 at tab 51, and that's MS 2277. And
Yep.
my lord, my lady, I'm going to ask you to look in just a moment at one particular provision. But before I get there, I'd like to just invite you in a quieter moment to compare and contrast between the VCCR and the VCDR. Article 31 of the VCCR, which is at MS 2289, Article 31, MS 2289, with Article 22 of the VCDR, which is at MS 994, and that deals with inviolability of missions.
Yes.
And you'll see that they're rather different. Inviolability of persons, again, Article 41 of the VCCR, MS 2293, Article 41, MS 2293,
Yeah.
and Article 29 of the VCDR, MS 995, inviolability of persons, the differences there. On giving evidence as a witness, Article 44 of the VCCR at MS 2294, and Article 31.2 of the VCDR at MS 996. And then on the issue of inviolability of residence, there is Article 30 of the VCDR, which is at MS 995, but absolutely nothing in the Vienna Convention on Consular Relations. But the important point that I'd like to take you to is to Article 43 of the VCCR, which is at MS 2293.
Article 43, immunity from jurisdiction.
Immunity from jurisdiction, precisely, my lord.
Yep.
And the contrast there will be with Article 31, paragraph 1, with which we're familiar in the VCDR.
Of course, yeah.
But I would simply invite my lords, my ladies, to read through Article 41. Consular officers, consular employees shall not be amenable to the jurisdiction of the judicial parties of the receiving state in respect of acts performed in the exercise of consular functions. So superficially it looks as if it's similar, but in fact it inverts the way in which the approach is taken in the VCDR. And then if you turn over the page, provisions of paragraph 1 shall not, however, apply. So immunity shall not apply in respect of civil action, either subparagraph A, arising out of a contract concluded by a consular officer or a consular employee in which he did not contract expressly or impliedly as an agent of the sending state. And that provision was an issue in Park against Shin, which Mr. Otti relied upon. And it's radically and fundamentally different from the VCDR provisions. There is no basis, in our view, to extrapolate from the VCCR to the VCDR. There is a clear policy choice contemporaneously made by the same draftsmen and women and negotiators and state officials. And in our view, the Court of Appeal in this case, in the Reyes against Malki case, was quite correct to disregard Park and Shin. My lord, my lady, that brings me to the approach to the interpretation of Article 31(1)(c). And I will, just to anticipate, my lords, my lady, like to take you back to the Vienna Convention on the Law of Treaties, which is at A5, tab 53, MS 2317. Before I get there, just to make a number of points. First of all, as you will have no doubt tired of hearing from me already, the VCDR is a multilateral treaty with 191 states parties.
Sorry, I didn't catch that.
I wasn't sure whether that was a joke, my lord. The VCDR is a multilateral treaty with 191 states parties.
All right.
I was just repeating what I'd said.
Sorry, thank you very much. No, it was not a joke, but perhaps like all the best jokes, it was not intended. Yeah.
The second point, just to make, no doubt self-evidently, but perhaps not, it is not UK legislation. Section 2 of the Diplomatic Privileges Act, which is at MS 968, I don't need to take you to it, but it's at MS 968, does not alter the character of the Vienna Convention as an international treaty. On the contrary, it's clear from Section 2 that the scheduled articles of the treaty are to have the force of law. The approach has not been adopted, as has been in some other cases, of transposing the treaty into legislation. It's simply scheduling the treaty.
Yep.
Both the character of the VCDR as a treaty of international law and its near universal participation, in our view, require that it is to be interpreted by reference to international law principles of treaty interpretation. And my lords, my lady, I'm going to tread into dangerous territory here because I'm going to refer you to a dissenting opinion of one of your brethren who's not here, and that's Lord Kerr in Muhan against the Lord Advocate. And I don't need to go into the detail of that case concerning the interpretation of Article 3 of Protocol 1 to the European Convention on Human Rights. The case is at A782, and the reference is MS 3059. And the small point that I want to make, simply because this is the clearest statement of the point that we've been able to find, is that he says that...
Sorry, which bundle is it in?
Seven.
It's in A7 at 82, 3059. He simply says, and it's a small point, I won't detain you long on it, that Article 3 of Protocol 1 is not to be read as if it was a Westminster or Holyrood statute. It's an instrument of international law to be interpreted according to that system's markedly distinct canons of interpretation, encapsulated in 31 and 32 of the Vienna Convention. And I, at my peril, stand to be corrected, but on reading that judgment, it does not appear that this was a point that divided the court, although there were other points that did divide the court. And my lords, my lady, the further point is simply to observe that Section 3 of the Human Rights Act concerns the interpretation of legislation. It doesn't concern the interpretation of treaties. It doesn't purport to lay down rules relative to the interpretation of treaties, or at the very least, it does not oust the application of international law canons of construction. And my friend, Mr. Swaroop, will return to this in the course of his submissions dealing with the human rights matters. We have in our written case relied on Fothergill against Monarch Airlines, as it is not quite the Fons et Origo, but certainly one of the early illustrious authorities on the interpretation of treaties. I don't propose to take you to that case, which is well known, but simply to refer you to some references by Lord Diplock and Lord Scarman. Lord Diplock is at MS 1128 and 9, 1128 and 9. And he's quoting, Lord Diplock is there quoting Lord Wilberforce, and then Lord Scarman, both at MS 1137 and 1140, 1137 and 1140. And the consequence of this, we contend, and correctly so, is that treaties ought to be interpreted by reference to the rules that are relevant to treaty interpretation, which is Article 31 and 32 of the VCDR. And with that, I'd like, if I may, to take you to the Vienna Convention on the Law of Treaties, which is at A553, MS 2317, and the provision, Article 31 and 32, with which you will now be very familiar. And I'd like to make a number of observations on this, if I may, and you will, I hope and expect, move me on if you think that I'm being too pedestrian on these issues, but it seems to me that in the light of some of the statements that have been made on the other side, a focus on the detail of the article and what's required might be quite helpful.
Thank you.
So a number of observations. First of all, Article 31 of the Vienna Convention on the Law of Treaties is a single composite rule. the heading is General Rule on Treaty Interpretation. It's not General Rules on Treaty Interpretation. And there is no suggestion that there is a hierarchy or sequence. And while it is common, as in the case of the Court of Appeal judgment in this case, to see analyses that move sequentially through ordinary meaning, context, object, and purpose, this is overly formalistic, even if it's not wrong. In our view, the correct approach is that this is a single combined rule. And if I may again give you a reference to Lord Kerr in Muhan against Lord Advocate at MS 3060. But here, happily for me, what Lord Kerr is doing is simply setting out the International Law Commission's view, so it's not necessarily infected by a dissent. Now, the provisions of a treaty are to be interpreted holistically, having regard to the treaty as a whole. And one cannot look at the provisions in isolation. And this is a matter of contextual interpretation. It flows from Article 31, subparagraph 2 of the Convention on the Law of Treaties. The context for the purposes of interpretation shall comprise, in addition to the text, including its preamble and annexes, etc. And the small point that I would take away from this, which I expect will not be disputed by Mr. Otti, but I think needs to be driven home by me, is that the same words and phrases used in different places in a treaty should, in principle, absent a reason not to do so, be given the same meaning. And, of course, to anticipate, Article 42 of the VCDR contains the phrase professional and commercial activities. The exact same phrase arises in 31.
Well, yes, hold on, for profit.
Yeah, I'm going to come.
Yeah.
My lord, I assure you, I will not miss out on that. It's
No,
just those words. Second point to make, because this may also be something of an anathema when it comes to the interpretation of contracts as a matter of domestic law, but the intention of the parties is controlling, and this is apparent. And can be inferred from the references to object and purpose, from the reference to, in Article 31, 2A to other agreements, by the reference in Article 31, 3A and B to subsequent agreements and subsequent practice, most acutely by reference in Article 31, 4 to special meaning, if the parties so intend, and then of course, recourse to the preparatory works, which is evident of intention. Then we have Article 32, which is headed supplementary means. And I accept that there is a hierarchy here. It's not a hierarchy that imposes very great obstacles, because Article 32 allows supplementary means to be referred to both in order to confirm a meaning resulting from the general rule, or where the meaning from the general rule is ambiguous or obscure. My lords, my lady, if I may, I would like just to dwell on the theory of the travaux, if I can put it in those terms, before we get to the travaux. In part because in the exchanges yesterday, it appeared, and maybe it was just a sort of frustration in going to bundles and digging out the relevant texts, it appeared that there may have been an inclination to consider that the travaux will not be material to the interpretation of the treaty. And we're going to take you to that, and we think that that's absolutely critical. But let me just be clear about the travaux. The preparation of travaux préparatoires, the recording of the travaux, is an acknowledged feature of the treaty-making process. And I don't need to take you to it because this is just a formal point, but if you have a look at the formality of the documents that are, for example, in Authorities Bundle 3 at tabs 25 to 29, that's MS 1714 to 1759, and there are also extracts in the supplementary Bundle 3, you'll see that these documents are immensely formal. They are not the scribbled notes of a junior staffer. the travaux are well known to states. There is a formal process of preparation and finalization of the travaux. They will be corrected before they are finalized. And statements accordingly are made by states formally and on the record. The travaux preparatoires are not informal records which are simply stumbled upon in the dark one night in search for a meaning. And in the case of the travaux preparatoires of the VCDR, these are absolutely commonly known. They are readily publicly available. They are systematically arranged. They continue to inform the views of states, not in this hearing, but the Secretary of State in his submissions before the Court of Appeal made detailed submissions on the travaux, and that's at Core Volume 2 at MS 837, and then at MS 833 and following. And the travaux inform the commentaries, such as Denzer and Satow, and they are relied upon by courts, such as Tabian. And they would undoubtedly be referred to were, for example, a dispute such as the issue that we are faced with here, to arise before the International Court of Justice, hypothetically between two states at odds with the interpretation of the VCDR. Undoubtedly, the International Court of Justice would refer to the travaux. They do it all the time. Now, with that, I would like to come to the scheme of the convention. And this is at A1 tab 2. And again, my Lord Newberger, with the express invitation, if any invitation was needed for you to move me on if you think I'm too pedestrian. While we've been taken to a number of points, there has been no careful review or analytical review of this treaty, and I would like to do so because it's material.
Well, I can well see it if we're interpreting a particular article in the treaty. One may be helped by looking at the treaty as a whole. I see that, yes.
Yes. I will run rapidly through some points just to identify them.
Thank you.
The purpose and function of diplomatic relations, we are happy to draw your attention to all of the recitals. We certainly don't want to shy away from Mr. Otti's recital number 2. Article 3, which deals with the functions of a diplomatic mission, and I would just very briefly pause there to note that Article 3 deals with the functions of a mission. It does not deal with the functions of a diplomat.
Yes.
And necessarily the functions of the diplomat will be broader. I've already touched upon the reciprocal character of diplomatic relations.
I mean, you're relying heavily on the functional purpose behind this convention, the 4th recital. At some stage, convenient to yourself, would you like to explain why those making this treaty might have said to themselves, it would really interfere with the functions of missions if we were to include, as an exception to diplomatic immunity, those employers of private servants who were diplomats, who treated their servants in conditions of slavery, modern slavery? You choose the word.
Well, my Lord, I will come to that. I suppose the first point to note is that apart from the reference in another context, and I emphasize another context by the Yugoslav delegate, Mr. Bartas, this was not the subject of discussion. But when it was raised, the special rapporteur from Sweden, Mr. Sandström, took the view, which was obviously accepted by the rest of the International Law Commission, that this was not a matter to be addressed. But no doubt...
I think you did say at some stage earlier this morning, it would have been so easy to say explicitly that one of the exceptions to immunity was this sort of situation, which led partly to my question.
Yes, exactly. And our conclusion is that it was not done because there was no intention to do it, because it could very easily have been done. But I will come to address that in slightly more detail.
If you would, please.
So the reciprocal character of diplomatic relations, Article 2, mutual consent. Article 47 is a differential application. And again, here I draw attention to the Secretary of State's submissions which are at Core Volume 1, MS 577. And the particular paragraphs that I would highlight for you there are paragraph 7, which is at MS 579, paragraph 11, which is at MS 581, and paragraph 31, which is at MS 587, where the Secretary of State expresses concern in 3 different ways, in 3 different places, about the dangers of reciprocally undermining the Convention. The premises of the mission and its inviolability.
Could you just give those paragraphs again? I'm sorry. Just the paragraph numbers.
Paragraph 7, paragraph 11, and paragraph 31.
Thank you. Yep.
So then the premises of the mission and its inviolability. The premises is defined in Article 1, subparagraph 1, and inviolability is addressed at Article 22. Then we've got a whole host of provisions, unsurprisingly, that deal with a diplomatic agent, with accreditation, notification, etc. And just to run through them, Article 1, E, and D are relevant to the definition of a diplomatic agent. Article 7 is relevant to the appointment of the diplomatic agent. Then you've got provisions in Article 10, subparagraph 1 and 2, which deal with the notification of arrival and departure of the diplomatic agent.
Yep.
Article 29, which deals with personal inviolability. Article 30, which deals with the inviolability of the residence of the diplomat. Article 31(1), which deals with immunities, as we're all very well now concerned with. Article 31, paragraph 2 is a diplomatic agent shall not be obliged to give evidence as a witness, which we have touched upon.
Yep.
31(3), no executions save in respect of 31(1) exceptional cases. 31(4), this does not mean that the diplomat is above the jurisdiction of the sending state, so the diplomat is not above the law, because too often defences of immunity are said to be claims of impunity. Then we've got a series of articles which I won't identify in detail, but Articles 33 to 36, which deal with exemptions from domestic laws. The one to draw to your attention expressly is Article 34, subparagraph D, which Mr. Otti has fairly already done, and which was part of the Court of Appeal's judgment, which was that the exemption from dues and taxes does not apply to dues and taxes on private income. Then we come to Article 38, paragraph 1, which addresses the diplomatic agent who is a national of or resident in the receiving state. And just to anticipate, if I can draw your attention to the language there, except insofar as additional privileges and immunities may be granted by the receiving state, a diplomatic agent who is a national of or permanently resident in that state shall enjoy only immunity from jurisdiction and inviolability. The relevant language for my purposes is in respect of official acts performed in the exercise of his functions. And my point in due course will be that this language of official acts performed in the exercise of his functions is not the same as 31(1)(c). Then we come to 39, subparagraph 1, which deals with the commencement of privileges and immunities from the moment he or she enters the territory of the receiving state on proceeding to take up his post, or if already in the territory, when his appointment is notified. And then 39(2), which Mr. Otti relies upon, but which we say is not germane. The functions of a person enjoying privileges and immunities have come to an end, or when the functions of a person enjoying privileges and immunities have come to an end, such privileges and immunities shall normally cease at the moment when he leaves the country or on the expiry of a reasonable period in which to do so, but shall subsist until that time, even in the case of armed conflict, and then the relevant language. However, with respect to acts performed by such a person in the exercise of his functions as a member of the mission, immunity shall continue to subsist. This is residual immunity. And once again, Our point is that the language of that second sentence is not the same, very definitely so, as the language in 31(1)(c). And not only does it refer to functions rather than official functions, but the characterizations of functions in 31(2) is qualified by saying his functions as a member of the mission. And that language is different and we think is material. Then we have Article 41, subparagraph 1, the duty of all persons enjoying privileges and immunities to respect the laws of the receiving state. And then Article 43, the functions of a diplomatic agent comes to an end, A, on notification by the sending state to the receiving state that the function has come to an end, or B, that's the PNG, the persona non grata, if a diplomat's declared persona non grata. Now, then there are provisions relating to family members, which are at the back, but nonetheless evident in this case. And once again, Article 10(1)(b) and 10(2) are relevant to arrival and departure of family members.
Yes, please.
Article 37 then provides that the members of the family forming part of his household shall, if they are not nationals of the receiving state, enjoy the privileges and immunities specified in Articles 29 to 36. And there is a small but curious point here which will be relevant, my lords, my lady, if you get to the 39(2) point, but just to flag it, because Mr. Otti, simply by referring to cases such as Wakuri and Qasim and Abu Sabib and the US jurisprudence on residual immunity, rather seems to suggest that the wife of the victim in this case will not be entitled even to residual immunities because Article 39, paragraph 2 is not incorporated by Article 37. There is, however, the oddity that Article 39 is the provision that determines when immunities come to an end. So if Article 39 is not engaged, there is a real question about whether immunities come to an end. And there would certainly be an argument about whether, you know, a vulnerable member of a household would have subsisting immunities just by reference to the interplay between Articles 37, Articles 39, and then 29 to 36. But it's not a point that I need to take. Then we've got the provisions on waiver, which I've already drawn to your attention. Then there are provisions relating to, which are relevant to abuse. And just to highlight that a heavy hand in relation to concerns about abuse, of course, is a breaking off of diplomatic relations. And Article 2 provides that diplomatic relations rest on mutual consent. So the breaking off of diplomatic relations is not a breach of the convention. And in the Indian case in the US, Kubragada, that I drew to your attention, you will recall that there were those press articles which identified the withdrawal of the American ambassador and
Yes.
concerns. Then we have Article 9, which is the declaration of persona non grata provision, which doesn't require reasons and requires immediate withdrawal in face of jeopardy.
Yes.
There are other provisions which would be said to address abuse, such as limitations on the size of the mission, waivers of immunity. And then we have the last tranche of measures that I'd like to, or provisions that I'd like to draw to your attention, because they go absolutely to the heart of this case, and that is private servants.
Sorry?
Private servants.
Private service, sorry, thank you.
And the first provision to draw to your attention
Which
is...
article are you referring to now?
I'm going to, now it's Article 1, paragraph H, subparagraph H. A private servant is a person who is in the domestic service of a member of a mission and who is not an employee of the sending state. So here we have the first of the provisions, and there are 6 of them, where the VCDR contemplates explicitly the employment of private servants who are not employed by the state. Then we go to Articles 10(1)(c) and D, and 10(2), which deal with notification. So 10(1)(c), the arrival and final departure of private servants in the employ of persons referred to in subparagraph A of this paragraph shall be notified, and where appropriate, the fact that they are leaving the employ of such persons. And then 10(1)(d) also shall be notified the engagement and discharge of persons resident in the receiving state as members of the mission or private servants entitled to privileges and immunities. So even private servants are entitled to privileges and immunities under the convention.
Well, that's in Article 37, isn't it? 37(4).
Yes, I will come back to that. So there is a linkage between that. Then, if I can take you to Article 33, paragraph 2, the exemption provided for in paragraph 1, which relates to social security provisions, shall also apply to private servants who are in the sole employ of the diplomatic agent. So once again, we have not just private servants, but private servants in the sole employ of the diplomatic agents, private servants who are not employed by the mission. And the remaining provisions of Article 33 also address this. And then, as my lady Baroness Hale has identified, we've got the provisions in Article 37, subparagraph 4, which deal with private servants as well. And then Article 38, subparagraph 2, other members of the staff of the mission and private servants who are nationals of the receiving state, etc. Now, the point that I make here, and I'll come on obviously to develop this more fully, is that the employment of private servants is part and parcel of the diplomatic compact, if you like. It was expressly envisaged, it was addressed in the treaty, and it's going to be relevant to my submissions on official functions. Then just to note, and perhaps because it may provide an opportunity for a little bit of speculation on the discussion yesterday about Article 42, not all of the provisions of this treaty were given the force of law in the UK. Generally speaking, the provisions that are given the force of law in the UK through the Schedule to the Diplomatic Privileges Act are those provisions which engage private rights rather than state rights. Article 42 is not, as I think my Lord Wilson and Ms. Hale raised and put questions to Mr. Otti on. I think, but our case doesn't turn on it, so I only make these points in case it may sort of satisfy curiosity. As we'll see when we get to the travaux, there was some debate about whether Article 42 was necessary because of Article 31(1)(c). And it may very well be that the United Kingdom took the decision at the time that there was no need to give effect to Article 42 because of 31(1)(c). It is absolutely the case that professional and commercial activity is therefore not prescribed as a matter of United Kingdom law. And what is interesting, but again not material to the case, and therefore there's no evidence before you, and that that is that the United Kingdom permits family members of diplomats to work as a matter of course.
Yes.
You get an exempt vignette and you can work. So the absence of Article 42 in the Diplomatic Privileges Act schedule allows that to take place. I think it's uncontested that by Mr. Otti that regard can be had to Article 42 for purposes of interpretation. Now,
but I mean, so far as Article 42 is concerned, if one of the diplomatic agents was a doctor who practiced his profession by going to charitable surgeries, for which he wasn't charged, he'd be carrying on a professional activity, but he wouldn't be doing so for personal profit.
my Lord, this, of course, is the point that Mr. Otti
yes, but do you agree with that?
Yes, and It is, of course, an element here that not everything is necessarily going to be wrapped up neatly, and the doctor who is undertaking commercial professional activities for profit will be caught. Whereas the one who is the Good Samaritan won't be. So if I can put it in these terms, the Good Samaritan is entitled to immunity. The one who's doing it for a dime is
Yes, I understand that. All I'm getting at is that the words for personal profit do add something, don't they?
Yes, this is not a case of surplusage as Mr. Otti suggested. Now, I would like then to move on to the interpretation of Article 31.
Yes.
I am proposing to start off the exercise, if I may, as an exercise of what might be described as naked interpretation. I'm not going to look at the authorities at all.
I understand.
Just go through the treaty. And as a preliminary observation, the reference to ordinary meaning in the Vienna Convention on the Law of Treaties is not an injunction in favor of a reasonable layperson's reading of the treaty. Mr. Otti described the ordinary meaning as the words that he used were a literal meaning. And it is not. The ordinary meaning is not the literal meaning. The ordinary meaning test is not a Clapham omnibus test. It's a requirement to give to the terms of a treaty the meaning that can be deduced from an ordinary reading in the context of the treaty as a whole and in the light of the treaty's object and purpose. Ordinary meaning is a lawyer's reading of the treaty, not a layperson's reading of the treaty. And it's relevant to Mr. Otti's attempt to sweep away Tabian, because the Court of Appeal of the Fourth Circuit in Tabian acknowledged that the literal meaning, that was the word they used, the literal meaning of commercial activities may be open to a different interpretation or ambiguity, but that the ordinary meaning for purposes of treaty interpretation was not. And Article 31(1)(c) uses the phrase professional or commercial activity. The only other place in the treaty where those words are used in that formulation is in Article 42, professional or commercial activity.
Yeah.
The phrase does not appear elsewhere in the Convention. And unless there is a clear reason not to do so, the phrase in Article 42 and in Article 31(1)(c) should be given the same meaning. And the wider language of Article 42 gives a good indication of what was intended by the words professional or commercial activity. And there were two elements to draw to your attention. The first is, as my Lord, you've just identified, the language of for personal profit, which adds something, and in our view makes it clear that the intention was to address income-generating activity undertaken by a diplomatic agent for his or her own purposes, distinct from his or her diplomatic functions. And we would also contend that attention has to be given to the words practice in Article 42. The diplomatic agent shall not in the receiving state practice for personal profit any professional or commercial activity. And practice, we say, indicates that what is in contemplation is continuous activity, a course of dealing, rather than a single act or even a series of isolated acts. We are not talking about acts, we are talking about activity, the practice of a profession or a commercial activity.
Exercise, not practiced, yeah.
Now, if we take this interpretation, and all of this obviously has to be undertaken with a caustic eye to see whether it's sustainable, but in our contention it is. If we take this interpretation into a reading of Article 31(1)(c), it is evident in our view that what is being addressed by the exception is continuous conduct undertaken by a diplomatic agent for personal profit that is distinct from his or her diplomatic functions.
Why should there be a requirement of personal profit in 31(1)(c)? I mean, what it's got in common with 42 is the use of the phrase professional or commercial activity. The requirement of personal profit is additional and presumably reflects the fact that Articles 31 and 32 are deploying the concept of professional or commercial activities for completely different purposes. The word is added to 42 in order to take out of the prohibition pro bono activities of one sort or another, a concept which is actually irrelevant to what 31(1)(c) is doing.
My Lord, I accept entirely that as a matter of, as it were, detached logic, that must be absolutely correct, that one could say that profit doesn't need to be imported into. What I'm contending is that profit in Article 42, just as the word practice in Article 42, is defining the interpretation of professional commercial activities into Article 42. And it is that is then taken into Article 31. Now, I will go further in just a moment, because I would like to observe the formality of the sequence of only getting to the travaux once we've been through the general rule. But the travaux make it quite clear that 42 and the language of profit was directly related to what was intended in 31(1)(c).
I mean, in 31(1)(c), one reason for not inserting profit as part of the concept is that there may be professional or commercial activities which are carried out in the course of the diplomat's official functions, particularly professional ones, so that presumably it would be largely meaningless to insert a requirement of profit in that context. You'd simply be earning your salary.
My Lord, I'm not sure that at this point that I'm able to assist on that point, other than to say perhaps I can come back to it once we've been through the travaux, because they are quite illuminating on the point.
You're making the point that it envisages an ongoing activity.
Yes.
Why is that? Why shouldn't it cover a one-off activity like taking a punt on some shares or something? Why wouldn't that be caught even if it's a one-off activity?
Well, we are saying that professional commercial activity is interpreted in Article 42 by reference to the additional helpful words which provide assistance in interpretation, and that the adoption of exactly the same phrase in 42 and 31(1)(c) is a good, if not dispositive, indication that that was intended also in 31(1)(c). And to the extent that there is any uncertainty about that, or to confirm the meaning that I'm now putting to you, when we go to the travaux, you'll see that that's exactly what was the intention.
42 looks like a prohibition against, so to speak, setting up shop. If a diplomat were to sell some of his surplus property on eBay, that might not be an activity unless he started buying and selling on a regular basis.
My Lord, I'm being drawn into a discussion of the travaux, so let me just sort of illuminate the point. In fact, in the discussion in 1957-58 of 31(1)(c), it was 29, Article 29, 1c at that point, the clearly expressed view was that setting up shop was prohibited for purposes of the 31(1)(c) exception. Now, there was no Article 42 at the time. Article 42 was injected into the convention at the last moment in the Vienna Conference in 1961. And there was quite a lot of debate as to whether it was necessary, and there was some suggestion that perhaps Article 42 should be removed, or maybe Article 31(1)(c) should be removed, because they both dealt with, as was perceived, the kind of the setting up shop, the carrying on the profession of the doctor. And there is a reference, and you'll see it again, by Sir Gerald Fitzmaurice, who was the legal advisor at the time, but also the ILC member, that it was not intended to catch the one-off, even the making of a turn, if you like, on selling a picture. But I hope that I will be able to wrap this all up in a bow once I've been through the issues.
Of course, if the relevant activity is employing a maid for 2 months, you could say actually that in this particular case there is a continuum.
My Lord, I suppose one could say so, and one could pass that up if it was only for 2 days into hourly portions and all the rest of it. We think that would be, as it were, reductio ad absurdum, I suppose. And again, on the I hope that this will be helpful. I'd like then also just to come back to Article 34D, which was also relied upon by the Master of the Rolls in his judgment in the Court of Appeal in this case, which provides that the exemption from dues and taxes shall not operate in the case of dues and taxes on private income having its source in the receiving state. We contend that reinforces the interpretation that is warranted of 31(1)(c), that it is concerned with income-generating activity. And as a textual matter, therefore, we say that Article 31(1)(c) addresses continuous conduct of an income-generating kind which is undertaken by the diplomat for personal profit distinct from his or her functions. And a wider contextual review of the Convention, in our view, makes it abundantly clear that Article 31(1)(c) was not intended to extend to the employment of a private servant by a diplomatic agent. And this follows from the 6 provisions in the Convention which actually address the employment of the diplomatic agent the employment of a private servant very explicitly.
How do you precisely say those references help to lead to that conclusion in relation to Article 31(1)(c)?
Well, first of all, we say that the employment of private servants by diplomatic agents is part and parcel of the diplomatic compact. It's required, in fact, by the treaty. I'm sorry?
It's not required, it's permitted.
Well, my Lord, I think it's probably true to say that it's required with a discretion to decline visas in individual circumstances. At least that's the way in which the United Kingdom appears to have interpreted. Tier 5 visa is a Tier 5 visa brackets international agreement, and it appears to be accepted that diplomats may bring, subject to the conditions of agreeing to pay minimum wage and all the rest of it. So the first point is that it addresses, the Vienna Convention addresses private servants and the employment of private servants as an explicit part of what is entitled to happen under the scheme of the Convention. Second, we contend that it goes also to official functions, for the reason that I identified, also having regards to the practice of the United Kingdom to which I drew to your attention, that the employment of such persons under visas that are provided by the United Kingdom requires the employer to be a diplomatic agent, requires there to be a letter of support from the head of mission, and requires that diplomatic agent to be a diplomatic agent who is subject to privileges and immunities.
Why does it follow from that that the employment of such a person is part of his official functions.
Yeah.
My Lord, may I come back to that in just one moment? Well, in fact, I can get to it straight away because I've addressed the points about the UK practice. In our view, the appropriate test of official functions is whether the conduct in question is engaged in under colour of a diplomatic agent's diplomatic status as part of the broader exercise of his or her functions. And the reason why we put it...
So it's enough on this definition, is it, that you wouldn't be able to do it in this particular way if you weren't a diplomat?
Sorry, my Lord, I didn't...
Does this mean that it is enough to bring it within the scope of official functions that you wouldn't be able to employ a person of that origin in this particular way if you were not a diplomat?
I think...
Is that the argument?
We would say that because this employment is explicitly envisaged and covered by the Convention, that because the way in which the United Kingdom has implemented this, which requires that it is employment by a diplomat, subject to all of the points that I've raised, that brings it within the scope of official functions. But we have the additional point that, on our view, the appropriate test must be a test which is a colourable functions test, because if it's not, every allegation of trafficking would engage an evidential inquiry. And indeed, one of the difficulties, this is not a point that Mr. Otti has taken, but it's evident from the case. One of the difficulties that Mr. Justice Newey faced in Wakuri and Kassem was the very considerable of finding the evidence that was relevant to his residual immunity interpretation. And in our contention, if the test is a sliding scale test, as Mr. Justice Langstaff in Abu Sabib against Tadesi set out, the question of where on that sliding scale the conduct came would become a matter of evidential inquiry. What was the domestic worker doing? Who paid the wages? Etc., etc., etc. And the problem of evidential inquiry is, we consider, very significant, particularly when we have Article 31, subparagraph 2, which is that a diplomatic agent shall not be obliged to give evidence. Mr. Otti, rather interestingly, says that is for him because the fact that a diplomatic agent is not going to be obliged to give evidence gives a measure of additional protection, even if 31(1)(c is as he contends. And we say, no, on the contrary, the fact that he is not obliged and maybe by his own relationship with his state prevented from giving evidence means that he won't be able to act in his own defence. There is a further point which I might simply make in passing, just to provide a little bit of additional underpinning for the ostensible authority or the colour of the diplomatic agent's status case. And that is that, I mean, Mr. Otti in his submissions drew attention on more than one occasion to the fact that there is an optional protocol to the Vienna Convention on Diplomatic Relations, which allows interstate suit to go to the International Court of Justice. And he sought to rely on this for purposes of saying, well, if there was a disagreement, he didn't put it in these terms, but almost, if there was a disagreement between Saudi Arabia and the United Kingdom, that this is a matter that would properly go to the International Court of Justice. Now, let's just reverse that hypothetical and do it in terms of the receiving state and the sending state, so that I don't make any diplomatically embarrassing sort of observations. If the receiving state decided to bring proceedings before the International Court of Justice against a sending state, because one of the sending state's diplomats had acted in an abusive trafficking manner in respect of a domestic worker employed in the receiving state. The sending state, the respondent in the action, would be able to defend the action if they were simply able to say, "That's not me. That was the diplomatic agent." The language of ostensible authority is also the language of responsibility. So if a diplomatic agent in the employ, in the process of employing a domestic worker, commits a violation, the sending state is on the hook because it is within the ostensible authority of the sending state. So our contention is that official functions is to be, that the test for official functions is a test of whether it is under colour of the diplomatic agent's status as a part of their ostensible authorities, and we say that it is. And we say further that this official functions analysis is not in any way displaced by reference to other provisions of the Convention, because the two other provisions that have been cited are Article 39, paragraph 2, which deal with the exercise of functions as a member of the mission, and Article 38, paragraph 1, official acts performed in the exercise of his functions. Neither of them deal with the same issue. They both focused on something else. The language of both are different. And we therefore contend that Article 39.2 and 38.1 do not assist. I should just say parenthetically that the conclusion that the employment of a private servant by a diplomat, the conclusion that it was within the functions of the diplomat, was a conclusion that was reached by the US District Court for the District of Columbia in Sabati against Al-Saleh, which is at A322 MS 1697, and the paragraph reference is paragraph 10 at MS 1704. Now, my lords, my lady, the Court of Appeal had resort to the travaux préparatoires for purposes of illuminating the object and purposes of the Convention, and I think Mr. Otti questioned whether this was the right approach, and I think it's probably correct to say that that was not the right approach. Travaux préparatoires did not come into play when it comes to an examination of object and purpose, but rather as part of the subsidiary rule. I would like to turn to the travaux préparatoires, because we say that even before we turn to the travaux, the meaning of 31(1)(c) is abundantly clear. And we have two propositions. First of all, that it addresses continuous conduct of an income-generating kind, which is undertaken by a diplomatic agent for personal profit, distinct from his or her diplomatic functions. And the second element that we advance is that it does not encompass the employment of a private servant by a diplomatic agent. And having reached that conclusion, we turn to the travaux for purposes of seeing whether the travaux confirm the meaning. And I don't propose to take you through all of the detail of the travaux, but if I may give you some references to where the travaux is addressed, both in our written case and elsewhere. first of all addressed in paragraphs 47 to 51 of our written case, and that's at MS 205 to 9. It's core volume 1. It was also addressed in paragraph 12 of the Secretary of State's case before the Court of Appeal, and that's in core volume 2 at MS 833 to 836. And there is also, I put it no higher than this for the moment, an interesting discussion of the travaux in the US Department of State's Statement of Interest submitted in Tabian and Mufti, and that's at Authorities 13, tab 167, and that's MS 5140 to 5147, 5140 to 5147.
Thank you.
And I would like, if I may, to go through the travaux by reference largely to the supplementary bundle. Supplement 3. And the tabs that I'm going to be going through sequentially, but for one sequence, are tabs 178. And at tab 178, and this is at page 60, we see the first reference to what was later to become 51.3, and that is in paragraph 70 on the right-hand column. On
Paragraph?
70.
Thank you. Mr. Vedros.
It's the
Thank you.
Austrian delegate.
Yep.
I'm sorry, could you just give me this page reference again?
Page 60 of supplement 3. And Mr. Vedros comes to the issue after the closure of the discussion on subparagraph B, which is more or less as was subsequently adopted. And then he says, introducing an amendment to...
Supplementary 3, page 60.
Page 60, yes, I'm sorry. Supplement number 3. Mr. Vedros introduced an amendment to insert in paragraph 1 a new subparagraph C as follows, quote, an act relating to a professional activity outside his official duties. And we see here only the words professional.
Yes.
And then he goes on in paragraph 71 and following to refer to the Institute of International Law,
Yep.
and the Harvard draft. And then we have Mr. Francois oppose the amendment, and this I think goes to my Lord Sumption's point, oppose the amendment as unnecessary. Diplomatic agents practically never engaged in any professional activity outside their official duties. If they did, and the receiving state objected, it could easily be put to an end, and we could easily put an end to such activities by declaring the agent persona non grata. Then the matter might arise if the agent was a member of the board. And then if we go down to paragraph 75, we see Mr. El Arian from Egypt supported Mr. Vedros's amendment. If a diplomatic agent engaged in a professional or commercial activity, the word commercial should undoubtedly be inserted into the amendment, so that's the origin of the word commercial. He should enjoy no immunity, but be treated on precisely the same footing as other persons who practiced the same profession or engaged in the same commercial activities. The case could not really be assimilated to that of divorce. The dignity itself of the diplomatic agent required that he should not engage in activities outside his functions. We then, in paragraph 77, come to Mr. Sandstrom from Sweden, the special rapporteur, who agreed by and large with Mr. Francois that the amendment should be opposed as one and was unnecessary. To engage in professional activity outside his functions would impair the dignity not merely of the diplomatic agent himself, but of the whole mission. And you can see here the harbingers of what became Article 42. And then jumping to paragraph 80, Mr. El Arian said he was prepared to accept Mr. Vedros's wording or any similar formulation and proposed it be put to a vote. And it was put to a vote. And if I can take you to the next tab, that's tab 179. This was the outcome of the vote, the text, and you can see on page 139 in the top left-hand corner, the draft provision that was adopted. An action relating to a professional or commercial, we see for the first time, exercised by the diplomatic agent in the receiving state outside his diplomatic functions.
Yeah.
And then, before, my lord, we adjourn.
I'm sorry, I think you must have given me the wrong page reference.
Very top of page 64.
Thank you.
Sorry, it was, I'm sorry, my lady, yeah, it was top of page 64.
Yeah, the 139 is the internal numbering, not, yeah.
Yes.
The next tab is tab,
180, yep.
I'm so,
Or do we go on?
my lord, actually, if this is a convenient time to break.
Convenient moment. Let's resume again at 2 o'clock. You remember that we've got an hour this afternoon. Good. Thank you very much. Court will now adjourn. Thank you.